Morning, everybody. My name is Mark Adams, Director of Compliance, and I'd like to welcome you to our March HR Compliance webinar, also known as our first HR Compliance webinar of spring. This webinar will be going for approximately 60 minutes, and please be advised that this webinar will be recorded. And if you haven't already done so, if you're logging in, please, if you could make sure you're logging in with your first and last name in the participant field of Zoom, we would appreciate it for attendance purposes. However, in thinking about the topic here that I wanted to cover today, I realize that we live in a day in time where it's all about polls. You know, I mean, I don't care where you are on the internet and social media, or even if you're checking your inboxes these days in your email, polls are everywhere. Educational programs are built around polls. We see articles and blogs that are built around polls, all with an eye towards kind of providing some perspective or takeaways that people should be aware of on just about any given topic. So from that standpoint, I thought, hey, you know what? Let's do a top 5 of HR mistakes that I often see out there when I've been dealing with companies or members over time. Now, I know one of the questions actually, as I get into this too, as I advance to the agenda here for today, is a lot of people often will ask, well, are you going to provide a copy of your slides? And certainly in the interest of time, I will certainly get those up there for people here. Certainly for people who have taken part, we also have the recording that we'll make available as well. But what I'll do now, just for people's added convenience, is also provide that to people here today. So if I can just get to that. Having a bit of a technical difficulty. I will revisit that a little bit later. I will be sure all attendees get it after today's webinar with the recording link. But as far as today's agenda for today's webinar, like I said before, of course, I'm going to go over my top 5 HR mistakes. That's after all what this program's all about. But in doing so, I am going to give you my reasons why. After all, it is one thing to have a take on a given issue. It is certainly another course of action altogether to have a reason behind it. So I wanted to give you some additional context and explanation for my positions, if for no other reason, just for the fact that if you are running into one of these situations in your own workplace, and it raises a call to action on your part to have to advocate some sort of change in how you do things as an organization, you want to be able to have some added context to be able to talk to your senior leadership team if you're not the exclusive decision maker to drive that change, to hopefully get the buy-in that you need to make things right. And with that all being stated, of course, too, you know, it's one thing to talk about problems. It's another thing also to talk about solutions. And, you know, a lot of times when we deal with employees, we might often tell them, don't come to us with a problem. Just for sake of complaining about something or putting a problem out there, bring a solution to the table that we can start considering how to fix things. So certainly, you know, with that spirit in mind here, The other thing I want to be able to bring to the table here is those takeaways and how you can avoid some of these mistakes, or if they're not, or if they've already been made, what you should be doing to take stock of those considerations too. And then of course, we want to make sure we're able to also entertain your questions along the way, and we'll try to get to as many of those as time will allow. And certainly that would be something you can put in the Q&A feature of Zoom or in the chat. I will be keeping an eye on both. However, in kicking things off, and also frankly along the way, I am going to be introducing each of my top 5 mistakes with a poll question to kind of usher things in, if you will. So let me just kind of kick things off with our first poll question. And that is the question of who would be considered exempt? So this is kind of just to get some perspective for you on where we're dealing with, because we're all coming into things from different levels of experience, and either that are shaped by our own work environment that we've been into from quite some time, or might be shaped by virtue of, differing businesses that we've been into over time. And some of us might be new in the field of HR. Some of us might be seasoned. Some of us might be jumping back into some of the tactical things, and we've kind of been away from things for a while. So wanted to kind of provide an opportunity for us to kind of jump in and kind of get a sense here as we jump into these mistakes. So if you can take your time and take a couple of minutes to kind of check some of these things out, we can then use that to usher into our conversations here. All right, I see a few more people still answering. Just about there. If you haven't already done it, please answer the poll question we're providing here today. And then from there, we will move forward. And I was also able to upload the slides into the chat, so you could feel free to download those at your convenience. All right, so I'm going to close this poll. I'm going to share the results. So we can kind of see here, we've got almost a split, if you will, of the answer options here between B and C. And really the answer here is C, for those of you that answered it that way. And the reason why it's C is, contrary to popular belief, not all jobs that are quote unquote exempt, and I use that term in air quotes, necessarily require the payment of a salary. Professional jobs, some professional jobs, I should say, allow for paying employees on a fee basis, whereby an employee gets paid a fixed amount of money for providing some unique service. So like, think of, for instance, an artist who, gets paid a flat amount of money for creating a unique painting for a customer, for instance, not to do the same work over and over and repetitive. Outside salespeople, for instance, can get paid on a commission basis. Computer programmers and certain other computer-related occupations, not your run-of-the-mill help desk job, I might add, can actually be paid on an hourly basis, provided that that's at least $27.63 an hour. That all being stated, many of the more common exempt jobs that are people try to argue and advocate as exempt, like managers and certain administrative jobs and even other professional jobs, often will have the additional requirement of paying a fixed salary as one of those prerequisites. So, that is, one of the things we have to take stock of here. And that kind of sets the stage for our first, mistake that I often find. And, my number one HR mistake is the misclassification of workers. Now, whether it is misclassifying them as an independent contractor when they should have been considered an employee in the first place, or if it is an employee and misclassifying them as exempt and not paying them overtime when they should have gotten overtime, misclassification of workers is ripe for mistakes and is a high priority of enforcement, including but not limited to the U.S. Department of Labor. I mean, certainly on a state level, it is on the radar of many state agencies, whether it is a state attorney general's office, like in the case of Massachusetts, or in Connecticut, the Connecticut DOL. Different states empower different agencies to kind of oversee the state wage and hour considerations that they have. And I know some of you on the line today operate in a multitude of states. So again, from a state agency structure, that's not all one and the exact same. But the reasons for this enforcement priority are many, okay? First of all, when you think of workers, they may be deprived of compensation or benefits that they otherwise may have been deserving, including coverage under mandated insurance programs, like workers' comp and unemployment. So that for people who are independent contractors, for instance, they might lose access to those benefits. Certainly, also, there's the question of, people that misclassified, as exempt when they're out, when they should be non-exempt. Of course, they're losing out on the added compensation that comes with being paid overtime for hours that they're working over 40. So in its totality, righting the wrongs of worker misclassifications is, in the eyes of federal and state officials, not only a matter of fairness, but also a matter of protecting them too. And like I said, there are numerous ways misclassifications can occur. I'm just noting some of these on this slide here. I don't know if any of these look familiar for you. Sometimes I've seen this whole adage, and I think sometimes CFOs and accountants are notorious for this. Sometimes even some frontline managers are like, well, let's just kind of bring someone back on a 1099, when in the past they were always doing the work like a W-2 employee because they were an employee. I mean, having people doing the exact same job for you and having some being treated as employees and some being treated as independent contractors can be a very major red flag there too. But also, there's also this other adage, and I've dealt with some on calls where they're like, well, all our employees are salary. We don't have overtime issues. And it's kind of like, well, okay, you're paying them a salary. And maybe as long as you keep them under 40 hours, that might be okay. But depending on the job, if they're working over 40, you might carry an additional burden when it comes to overtime. When you think about, well, is someone answering the phones at your business? Is someone just doing simple filing of paperwork? I mean, those often are non-exempt jobs, in the grand scheme of things. So again, there are often situations here where that comes into place. And on the flip side, I talk about treating salaried workers as hourly workers, and this gets into the idea of how we pay them overtime? Are they getting a salary in name, but how we pay it and how we chip away at it really reflects a whole different approach when it comes to how they get that salary? So there's a whole litany of issues here. There was actually a case a short while ago that some of you might have seen online, where there was employees that were working on a rig as managers that weren't paid a fixed salary, but were paid a daily rate in their role as a manager, not as a professional, mind you, but as a manager, just for doing managerial duties. And these are people that were pulling in upwards to $200,000, but they weren't paid properly as a salaried individual. And as a consequence of that, the courts found that they were non-exempt. So there's a whole different array of issues that often can come to light here when it comes to either, are we treating people as employees in the first place, where we should? And then two, are we paying them properly when it comes to that based on what they do for us? And again, that doesn't always lead to the same one-size-fits-all approach on that. Now, again, when we're talking about the why is the, as I like to call this, and this is going to be a reoccurring theme, why is this a biggie? And again, this kind of gets into your understanding of this to be able to have that conversation on, the impact of this to the bottom line of your organization. I mean, when we're talking about misclassification issues, it can introduce a wide array of penalties and costs for employers, and those can vary greatly. So for instance, misclassifying someone as exempt, when they should be non-exempt, like I said before, it could open up the employer to back overtime. And for an employee who's classified as an independent contractor where they should have been an employee, can open up you as the employer to liability for, not only the potential for a wage and hour claim, depending upon the facts, whether that is a minimum wage claim, an overtime claim. But like I said before, misclassification could also lead to, additional liability under state unemployment or workers' compensation laws, which could come in the form of fines or even a stop work order upon you that could be levied by the state. I mean, often workers' compensation agencies carry that hammer over you, depending on the state law in question. And then, of course, there's also the failing to therefore withhold proper federal income tax and the employee's share of things like, FICA, which consists of Social Security and Medicare taxes, as well as federal unemployment taxes, what we call FUTA, may also likewise subject you to civil and criminal penalties on that level too. Specifically, as these are supposed to be paid quarterly to the IRS on an employer's quarterly federal tax return, otherwise known to some as the 941 form. Penalties associated with filing that form can potentially come to bear in the form of a penalty, which could be, not only 100% of the unpaid withheld tax that should have been withheld, but there can even be criminal penalties that are possible for willful violations of with fines up to $10,000 and even imprisonment, no less. And then finally, there's also the potential of being on the hook for benefits related to what was not properly extended to such an, individual. So when you think about things like workers' comp, for instance, and someone gets injured on the job and they're out of pocket, the medicals that should have been picked up under comp, well, guess where they're going to be coming for, relief, should that be an issue there too. So, I mean, you can kind of see the derivative impacts that can come depending on the situation that you're dealing with people. So how do you avoid this mistake or trap? Well, in the big picture, you need to have a working understanding of what your individuals do in supporting your business. For those that are classified as exempt, why are they? For those that are administrative, for instance, do they work in a business operation where they possess independent discretion and judgment? In business operations that are merely indirectly as opposed to directly tied to the goods that you produce or the services that you provide to your customers or clients? Or are they actually providing those services or actually producing the goods? Or are they in reality clerical in nature with no independent discretion whatsoever? Are your salespeople truly outside sales, or are they inside sales or telemarketers? And then when it comes to your managers, are they really managing people? And what we mean for that from a wage and hour standpoint is, 2 or more full-time equivalents. Or are they just simply manager in name alone, and they're managing the service, but not the people? That there's no one that, that report to them. For those that are independent contractors, is that really true? Or are they doing, the work that others that are classified as employees are doing? Is the work that they're providing or the services that they're provided, really directly tied to or unrelated to what the business does? And to what degree are they really kind of on their own and autonomous in providing those services, or is it really being controlled by management? If you're finding the answers to some of these questions are really raising concerns, then you really need to consider reclassifying those people accordingly. Now that's going to lead us now to our second poll question of the day. And that is the question of, and I see a question here that's popped up on our first answer. Question about receptionist who also functions as a site manager on an hourly basis, but provides the site manager a fixed stipend. What you're getting into here is when you get into people that are performing both exempt and non-exempt functions, ultimately, at the end of the day, it's going to focus on what is their primary job responsibilities. Okay. And that's not necessarily what they spend the majority of their time doing, but why does the job truly exist? So you kind of have to look at that holistically as to whether the primary duties focus on exempt work or whether it focuses on non-exempt work. But again, if it focuses on exempt, don't lose sight of the fact that if it's a managerial exempt job or administratively exempt job, you still have to pay them a salary. Mere stipend may not be sufficient to meet that obligation. Because again, administrators and managers can't be paid on something other than a salary basis. They can't be paid on an hourly rate basis. So that's kind of like a two-prong, a two-prong answer to that question. So in any event, what I'd like to do now is usher in our next poll question. If I can get the new poll question up. There we go. So our second poll question of the day: when do you pay an employee that is terminated by you? How does this work? And again, I know we've got some mixed people here, so we'll see what the answers to provide. I got a question also in the chat that popped up from going back to our first question. When you talk about using staffing agencies, and that might provide you with talent or labor, call it what you will, be mindful that you have joint employment considerations over the people that are working for you. And ultimately, when it comes to wage and hour considerations, a person could conceivably come after either the staffing firm or you if those things are not taken care of. So I think one of the things the only thing I can answer in that question would be, you really need to look at your professional services agreements with those staffing firms to see how they protect you. Or is there indemnification language, for instance, built into those where you can seek relief if you're on the hook for something that they did wrong? That might be something to take a deeper dive on those fronts. All right, so I think we'll close this second poll. I am going to share the results. And we can kind of see here, we got some mixed answers, but the answer here actually is D. Not all payment of wages laws are written the same. So for instance, in Massachusetts, for those of you on the line that are in Massachusetts, it indeed is day of discharge when a person is terminated by you. But there are other states out there. Connecticut, for instance, provides for the next business day. Rhode Island even goes down to the next regular payday, though there are some circumstances where it's within 24 hours if a business is being liquidated, and that's the cause for the termination. So the point I just wanted to make here, especially for those of you on the line today who may be multi-state, is pay close attention to these considerations, as failing to comply with how you pay people that might operate in a given state for you can bring some risk to you. And that gets into our second HR mistake. The next big mistake comes with when and how people are paid. And like the poll question kind of refers to, this can vary by state between states as far as that, and what you specifically need to pay them as well. As far as when you need to pay them, it may be that you need to pay non-exempt employees on a weekly or biweekly basis. Some states even allow you to go on a semi-monthly basis for that. For exempt people, it might even be that you can go monthly. Again, all states are a little bit different for that. And for those that are paid, and for those that are salaried exempt, again, are you paying them their salary week in and week out? If you are not, then the question becomes, why are you deducting from their salary? What are your deduction practices? Are you making full day deductions as permitted by federal wage and hour law for things like personal day absences, or full day deductions for absences related to sickness in accordance with a bona fide sick plan, for instance? Or are you making partial day deductions for pay? And if it is that latter situation of partial day deductions, is the difference being accounted for by the use of, PTO, vacation, sick time, what have you, or not? Making deductions from a salaried person's salary in a manner that provides the appearance that you're treating them like an hourly employee, can have the potential of them losing their exempt status under wage and hour law. And then again, bringing on the potential for liability for back overtime as a consequence of that. And the other thing I will say out there, and you can talk to a lot of attorneys out there that operate in the employment space, since a lot of these specific issues tend to be of the systemic variety. In other words, a lot of times it's not just a question of how you handle one exempt person on these type of questions, but often that's how you treat exempt people across the board when that topic comes up. These cases can often open the door for class action lawsuits, and that can just multiply the potential risk of liability that can come to bear depending on how many people have been treated that way. And then comes the question of what needs to be paid. What is wages, for instance? Vacation pay, for instance, is wages in Massachusetts. It's also wages in Rhode Island, of course, if they've been with you for a year in Rhode Island. But that isn't an expressed obligation in Connecticut on that. as that depends upon the structure of the vacation policy as to whether it needs to be paid out or not. For people that leave an employer, generally you can pay them in accordance with your next payday for wages owed when they initiate the separation, quit, retirement, resignation. But again, like the poll pointed out, for situations where you are initiating the separation, it can vary. Even New Hampshire, for instance, allows 72 hours to get that done. So it is important to be mindful of that, because if you don't pay people timely, there are damages to be had under state payment of wages laws. Certainly in Massachusetts, for instance, it allows for up to triple damages for doing so. Some states allow for double damages when it comes to that. When in doubt, if there is a challenge and you have questions of making a true accounting of what you need to pay out to people, it may be worthwhile to suspend the employee to ensure that you can take the time and opportunity to kind of dot your I's and cross your T's when it comes to that, rather than doing something prematurely, realizing that you didn't pay people properly, and then you've got potential liability on your hands. So again, how do you avoid this trap? Evaluating and reviewing your payroll records is a must to see when and how deductions are being made when it comes to salaried workers. And then, of course, examine your policies to determine what is getting paid out at termination. And for those on the line today who may be operating, of course, in multi-state fashions, whether it is that you have physical offices in multiple states or you have remote workers working for you, though they are providing services based on, working from home in another state, remember to be mindful of the states and those considerations, as they will govern those people generally. So getting into some of the questions here, if you have a salaried non-exempt employee, and you can have salary non-exempt employees, there are some people that will pay like administrative people on a salary basis and just keep their hours below 40. Should there be a time record procedure to track hours for overtime purposes? Yes, because if they ever end up over 40, and they truly are non-exempt, you're going to have to figure out what that halftime obligation is. That salary is not going to be the end all be all on that. And we got a remote question. We have a lot of fully remote employees who work in other states. If they are fired, do we go by the home office state or where they reside? It is the latter. So again, you got to do your due diligence on that to make sure you're accounting for things. Just because you might be based, for instance, in Connecticut or Rhode Island, you got an employee, let's say in California, California is going to govern them in those type of cases. All right. Good questions. Good questions. So let's launch our third poll question of the morning. So here is the poll question. When do I offer COBRA coverage? Seeing the answers flying in. There's one thing we know with COBRA, there are a lot of timelines that are built into COBRA for differing things, different tasks. Some of those are borne by you. Some of that is borne by your people that are on your plan. So let's see what things look like here on this poll question. Give it another minute or so. All right. So we'll bring this poll to a close. We will share the results. So when we're talking about COBRA coverage, there is response, well, when we're talking about COBRA, COBRA is the law that requires us to offer health insurance continuation options to people who are on the health plan on a day before a qualifying event, so that they have the wherewithal to continue their health coverage for a certain preordained amount of time. And that specific amount of time can depend on the qualifying event and who we're talking about. Is it the employee? Is it a, spouse or child, as the case might be? And COBRA applies to employers with 20 or more employees. Some states have coverage requirements that cover employers of less than that size, have what we call state mini COBRA laws, and those vary. But the general rule of thumb is under COBRA, once an employer becomes aware of a qualifying event, they have 30 days to notify the plan administrator of that existence of the qualifying event. And they in turn have 14 days to notify the qualified beneficiary and provide the COBRA election notice. Now, for those of you on the line today who wear both hats as the plan sponsor and plan administrator, that can provide you, of course, more time when you consolidate those timelines. Though, as many will tell you in the day, when it comes to COBRA administration, it's often not worthwhile to prolong getting those notices out there. The quicker you can get them out there, the more beneficial things are in the long haul when it comes to that. But B is the answer. So that then leads to answer or mistake number 3. And that is failing to offer COBRA coverage properly. I mean, we all know the topic of health insurance is a big issue. Health insurance is certainly not getting cheaper these days. It's getting more and more costly, and I think that's probably the understatement of today's program. But for the employees and their family members who are on these plans, I mean, it can literally be a matter of life and death, depending on the facts, right? In terms of accessing, health insurance. So when it comes to those who might otherwise lose coverage with you, ensuring that you are providing continuation options properly under COBRA is an absolute must, because failing to do so, as we will see, can be very expensive proposition for employers. And there are a lot of ways we can slip up here, from not extending COBRA at all to qualifying beneficiaries. For instance, those on the plan on the day before the qualifying event, to notices not being complete, to notices not being accurate on what qualified beneficiaries have to do as far as electing and paying for continuation coverage, to not conveying to people that they are not eligible for COBRA and why. There are notice responsibilities that you need to get out there if COBRA is not available. For instance, is it that, well, gee, it's a, they engaged in deliberate misconduct, and that it therefore does not mean that they have the right to continue COBRA for something like a termination, for instance. And again, that's a high standard. I'm not saying every involuntary termination rises to gross misconduct. That's something you certainly have to make a case-by-case assessment on, probably in collaboration with your carrier, so that you're making sure you're not, on the flip side, offering COBRA coverage when you shouldn't be either. But as you can see here, there are many ways we can drop the ball here. Does it cover all employer group plans? I mean, when we're talking about, for instance, federal COBRA, it can get into company-sponsored health insurance. It can get into company-sponsored, group health insurance, group dental insurance, group vision. People can have COBRA election options for any and all of those separate plans that you might provide to employees. So are we putting all those things out there when it comes to that? When we're talking about putting it out there, be mindful that, your qualified beneficiaries all have their own election rights, when it comes to that. Two, you might have an employee that wants to decline COBRA coverage, but it might be the spouse and kids that want to elect it. So it can go any which way when it comes to that. And when we're talking about premium payment shortages, the question then becomes, how are we handling those? Is that going to be accepted on your part as being sufficient for them to maintain their continuation coverage if they've elected it? Or is the premium payment so short that it wouldn't operate for them to maintain their coverage? Are we being clear with our beneficiaries as to how that gets corrected so that we're not conveying something in an unclear way where they think, oh, I can just give them, 60% of the premium and think I can still keep my options open? Are we being clear from that? You really need to have clear conversations with your broker and your carrier regarding how those shortages are to be handled, and is that being properly addressed in your election paperwork? So again, why is this a biggie? What can the penalties be? Well, there are a number of them. You certainly have, because COBRA does have regulations under the tax code, there are excise tax penalties that can apply as noted here. But then the ultimate hammer can be to ultimately being liable for uncovered medical expenses. So for someone that incurs medical expenses out of pocket that otherwise would have been handled through COBRA coverage, they might try to come after you for those, and those costs can be rather expensive. And I don't think we need to go over how expensive medical procedures are these days. But just as I was kind of doing some research before today's webinar. And in case you were wondering, did you know, for instance, that the average cost of heart bypass surgery was over $60,000? That according to Sidecart Health on their website. You can kind of Google that, but you can kind of get a sense if someone's going to be out of pocket with that medical bill, who do they think they're going to come after for retribution when it comes to those things? I mean, that's where big ticket COBRA claims can come into play here. So what should you do? Examine how COBRA administration is being done by your organization. Is it being done by you in-house? Is it being done through a third-party administrator? Do you have any idea if you're stepping into things new to your business? You want to really kind of vet that out to make sure your bases are being covered. And again, are current COBRA notices being used or not? The Department of Labor has on their website, current notices that you can use, not only for model general notices for people that are going on to your plan. As an employer, you've got to make sure you're providing model general notices no later than 90 days upon plan enrollment. That can be done through standalone notices, or it can be done through your SPDs. You can build those in, but are current notices being utilized? And the same thing with election notices too, I might add. And are they being filled out properly? I mean, when you think about COBRA, you got to make sure, are you reflecting the proper dates of what is considered the qualifying event, depending on the situation? Are you articulating proper dates for when payments are to be paid or be made and how? First payments are supposed to be made within 45 days of the election and covering health insurance back to the date of the qualifying event. Subsequent payments can be made upwards to 30 days in arrear. There's a 30-day grace period, in other words. But are you kind of indicating when the initial timeframes are for making those subsequent payments? Is it on the first day of each month, for instance? And what is the dates when COBRA coverage would begin? Are you noting all the proper plan options that are available? And perhaps, and most importantly, can you prove that you provided the notices to qualified beneficiaries when push comes to shove? Remember, it's on you as the plan sponsor to ensure that those notices were provided in the first place. Can you demonstrate that to show that you've met your obligations? If you can't, that can arguably put you at risk there too. So that, as you can see, not only are the costs the driving factor behind why this is my number 3 in my top 5, but just by the multitude of ways that the ball can get dropped, COBRA really deserves its place on this poll. And that leads us to then our 4th poll question. And this isn't a direct compliance question as such, but it's more, look in the mirror and give me your candid assessment. This is a safe place. It's anonymous, but what is your confidence on how you're handling I-9s at your business? And I'm not giving you 4 answer options. I'm just giving you 3. What one best applies from your seat? Are you running a tight ship? Well, we're not quite sure, or we're just afraid to even look in the files. Where do things stand? If you were to really take a step back, think long and hard, what answer best applies to you? All right. So there's not an automatic right or wrong answer here, right? So I'm going to end the poll. And I'm going to share the results. And a lot of you are fairly confident, majority of the attendees today, that we're really on top of our game when it comes to I-9s, and, good for you when it comes to that. But we do have a fair number of, people on the call today who, not quite sure where we stand as organizations when it comes to that. And I think I also find for a lot of these, it might be that, okay, there's been a changing of hands and handling this responsibility over time. And are we all on the same page when it comes to that? Or maybe you're new to your organization and you don't really know what you don't know. So thank you for being upfront and honest in the poll question. And that's going to usher in our number 4 mistake. For my 9s, where do we begin? First off, I will say there's a lot of ways that you can drop the ball here and do it wrong. And we could spend all morning talking about I-9s alone. Think about it. You fill out the wrong spaces. You're not obtaining and reviewing proper documentation or the right combination of documentation. You're not identifying the documentation properly on the form. You're not signing the form in the right spots. And that could be something both that the employee could do wrong as well as management here. You're not re-verifying when you should be, or you're not doing it timely. And then you're not using the most recent form that you should be at that given point in time. When you think about this, the whole purpose of the I-9 was what? The principle was pretty simple. We need to show as employers that we have reviewed and are employing people that are lawfully authorized to work in the United States. But, this form, by all accounts, when you really think about it, let's face it, the federal government has over-engineered this whole process. And obviously it's become exceedingly complex over time. I mean, when you think about, all the things that we've talked about here, one of the things I would put out there that a lot of people don't realize is there are differing levels of violations for the I-9. There are technical violations, or what some would call more of the procedural variety, and those tend to be a little more benign, and that can be, things that aren't completely filled out on the form, so for instance, your failure to ensure, like if you've got somebody who is not, for instance, a US citizen on section 1 of the form, and they check off, one of the boxes, but they just forgot to put their A number down. Or, they failed to, you got an employee that doesn't indicate other last names used on section 1 of the form, but they had other last names and they forgot to put those things down. Or you think about something like, maybe they provided the documentation, okay, but, for whatever reason, you didn't take note of certain, the name of the document, you checked it off, but you didn't identify the specific one. Those can be technical violations that can be corrected by adding that stuff in, or lining through and putting in the right information there. And then you get into things that are substantive issues. When you get into things like they didn't produce the acceptable documents at all. They produced the wrong combination of documents. You didn't use the right I-9 form version in the first place. You didn't sign the forms where required, for instance, on the re-verifications. There are no employee or employer signatures on sections 1 or sections 2 of the form. These are more of the substantive varieties, and you just can't correct the original form. You really have to use a new form, which would be whatever the current version is at that time, and then creating a memo to demonstrate and note the circumstances behind that. So there are differing remedies for how you deal with things, and some of them may not be fixable. I mean, when you think about it, if I'm running into a substantive error and I'm having to fix it, but the person's no longer employed by me as the organization, and they're the ones that have something that needed to get done, like an employee signature, well, that is going to be something you're not going to be able to get your arms around, right? As opposed to a person still working for you, there might be pathways to fixing substantive errors that are attributable to the employee. So again, we could spend all day talking about I-9s, but because of the differing types of errors and because of the differing penalties, this can certainly become a very expensive and costly proposition. When we're talking about this and I get the call in the hotline, well, how much is it? It really depends. And I've got the slide here. When we're talking about the paperwork of the I-9, there's a vast range of penalties, when it comes to what you could face. And really, United States Citizen and Immigration Service carries a lot of discretion over the fine they want to impose. This range is rather large, and the fines can be levied on a form-by-form basis when we're talking about that. And the question gets into, they have these factors where they can also adjust up or down those penalties based on what they see in an audit. Is this the first time they've dealt with you? Or is this a reoccurring theme that's been on their radar with you when it comes to that? So again, I don't think anyone from the outside can automatically give you an exact to the dollar number when it comes to these things. As employers, you need to keep your Form I-9s for 3 years after hire or 1 year after termination, whichever is later in time. So when you think about that, there is the potential for a sizable amount forms that could be yielded in an internal I-9 audit. And therefore, when you think of these penalties, they can ratchet up and up and up, depending on how pervasive those errors are with the forms you have on file. And then, of course, there's even separate criminal penalties apart from the I-9 for knowingly hiring or continuing to employ unauthorized workers. So even if the I-9s are spot on, there's knowledge out there that there are people who are illegal based on other information that's out there. That can create additional penalties altogether. So again, there is a whole tier of penalties to be mindful of when we're talking about this. So what can be done to manage the potential risk? Well, particularly if there have been many people involved over time in your company's I-9 process, is that it probably is a good time to see if your organization has been doing them consistently. And that means, doing an internal assessment of what you got. And then also is the question, and I've got the link here on the slide, but there is, this page allows you to navigate and identify the revision history of what form was the right form in place at a different point, at a given point in time. I mean, for now, knock on wood, the current version of the form is our October 21st, 2019 revision date. Prior to that, it was a July 17th, 2017 revision date. And you'll see on here, different forms allow for different versions to be used at given points in time. Sometimes, again, it truly varies and you have to really look at this. But some other common issues, like I said, check section 1, has that been completed and signed and dated by the employee properly upon hire? When it comes to section 2, are you noting the right documentation combinations? And has that been signed and dated by management within 3 days of the employee beginning to provide services for you for pay? And when we're talking about section 3, is that being filled out when there was a need for re-verification? So, like I said, those are some of your starting points when you're starting to look at your I-9s. I got some questions, who gets picked for an I-9? That can really run all over the place. A lot of times it's just, complaints, people who have tipped off the feds. Could be an employee, it could be a disgruntled worker, it could be applicants. It can run the map that way. As often what I've seen for the I-9s out there. Question of, have they come out with a new form as of yet? The 10/31/2022 reference is the OMB expiration date. That has continued to be extended past that. I would expect at some point in 2023, we'll see a new form out there. Been a lot of talk about that, especially attributable to the remote work issue that came to bear with COVID. Those temporary rules with that are set to expire at the end of July. All right, so I'm going to get to our last poll question and our last couple of slides as we approach the bottom of the hour here. So let me launch this in earnest. And that gets into another self-reflection poll. World of documentation practices. What are we keeping track of? And this should be a check all that applies. It's not a one simple answer. You can check off a multitude of these. See people jumping right in here. Thank you very much. All right, I've got just a few more. If we can do a quick wrap on this, that'd be great. All right, I'm gonna end the poll now. I'm gonna share the results. We're not keeping everything. And again, some of this might not be relevant to your organization. A lot of you are keeping a lot of stuff in a multitude sort of ways. But there are some things that most of us are keeping. There are a couple of things maybe that we're not keeping as much as others. But I just wanted to put this question out there more for you to kind of reflect upon. Gee, never quite thought about keeping this on file in our offices. Maybe we should. Because when it comes to a lack of documentation, I mean, first of all, just because this is my final mistake in my top 5, it's by no means the smallest. But arguably, if anything, it's the broadest mistake that can be made. If you don't have that paper trail out there, it can really be an issue on so many different levels, when it comes to that. And a lot of times when we deal with hotline calls at EA&E and we're dealing with an employee dispute or something like that, and it's like, okay, we might, have some potential suit on our hands. The question often becomes, are we in a position to stake a claim and defend ourselves the way we want to? And a lot of times a lack of documentation can be really an Achilles heel for us when it comes to that. But it can come in numerous forms. Failure to have key policies in place that we are required to have based on federal or state law. Think of like harassment policies, for instance, or forms that related to how we hire and pay someone, all the way down to how we manage our employees, how are our performance management practices, and when and how we're holding people accountable if they fail to meet our standards, to even down to how we conduct investigations to ensure what actions that we ended up taking or not taking. Not that those are going to be in personnel files per se, those might be in separate confidential folders when it comes to that. But, without, this documentation, I think at the end of the day, it just opens you to second guessing, depending on the situation, or even litigation outright, if we're talking like discrimination, harassment claims, retaliation claims. For our Massachusetts employers out there operating in this day and age of mass PFML, that concern about retaliation is particularly troubling if you got someone that maybe wasn't managed the way they should have, and then they went out on a PFML claim, and now all of a sudden we're going to try to ramp up and hold them accountable for stuff. Do we really have that paper trail preceding the PFML that would give us some basis to sidestep those concerns? So the costs and penalties can vary dramatically depending on the disputes here, whether we're talking about lost wages if someone no longer is working for us, or emotional distress awards, even down to like harassment, discrimination cases that end up in court. There might be punitive damages, might be attorney's fees, court costs. They can vary greatly here when it comes to that. So again, how do you avoid these traps? Well, I think you kind of have to look and see what you're tracking systematically. I mean, I've done, and EA&E's HR partners have done HR audits and reviewing personnel files. And sometimes we come across an inconsistent approach of what's in those files that really shows that we're inconsistent as organizations, or maybe there's inconsistencies between or among departments. Or maybe we're commingling medical records in the personnel file where those need to be kept separate under ADA. Or worse yet, we're incorporating I-9s in a personnel file, and those should be kept separate under our I-9 rules. Or let's just say you got your structure all in order, but when you really look at the documents, it's based on ambiguities, generalities. Things aren't really consistently tied together. Don't really reflect how we're doing things as from a policy perspective. So, I think all of those are areas that could create potential risks for you down the road. And then, of course, there's just the question of, are we also documenting the things that we are doing? I mean, if we're going to say, well, we're going to hold you accountable for not doing your job, and you're right, that's reflected in your performance reviews. Are we documenting what we covered in our onboarding practices? Are we documenting that we trained them up in their job? Are we setting the stage for them to do their job effectively, so that the performance, so that the corrective action or the things in our performance reviews have their place and should be done? Or maybe we dropped the ball at the inception, and maybe those aren't the proper paths to take, and maybe we should go back around the bend to retrain somebody rather than writing them up. I mean, these are all these disconnects that can be, like I said, raised down the road in how we handle people. So, like I said, it's the last one of our top 5 here today, but it really has tentacles that can go in a variety of different directions and can haunt us. So I know we're a little bit over looking at the questions, and we answered them along the way. So no further questions on the table. So, how long do you need? I just saw one pop in. How long do you need to keep I-9s of terminated employees? You need to keep them, again, the record retention for I-9s is 3 years or 1 year after termination, whichever is longer in time. The one thing I'll throw out there as an additional caveat, if a state personnel record law would cover an I-9 and have a longer duration, then that could kick it out even longer under those circumstances. All right. So that's what I wanted to cover here for our March HR compliance program. I'd like to thank you for your time. Certainly, if you have questions, on this or other topics, our hotline's always there to service your questions and needs. But we hope that some of these topics and takeaways will help you along the way avoid these pitfalls and problems. So hope you enjoy the rest of your day. Take care.